My name is Tony Canales, lawyer from Corpus Christi. I have about 7 to 10 dentists, medical doctors right now, all involved in litigation regarding the payment holds or the overpayment hearings.
You're for this bill or against this bill?
I'm for the bill.
Okay.
The reason this bill has come up, oh, by the way, and Mr. Stick has talked about some case that he lost so far. Well, that was my case. There's only been one case tried. And that was my case. There has not been any overpayment hearings held. I've got the next one coming up. So I'm there, and the reason I'm here to sponsor this bill was because I saw a particular weakness for a citizen having a contract with Medicaid. And so what I did was, the weakness was, who is going to decide, forget the payment hold, who's going to decide the overpayment hearing? And I said to myself, well, I'll go down to SOA to decide the overpayment hearing. And I said I couldn't be there. SOA said, rejected me. Do not come here for the overpayment hearing. Where do I go? Go to HSSC. Go to these fellows right here. And guess what I did? I went down there to them. I followed my request at HSSC Appeals, and I said, I want you to go to SOA. They responded, no. I wasn't happy with that request. You can tell my little personality. I just can't take no for an answer. So I filed a lawsuit at District Court in Travis County asking that my case be sent over to SOA. The Attorney General's office and these fellows, and Mr. Stick himself, they all wrote briefs and letters and said, no. In essence, this is what they said. No agency statute mandates or permits appeals of the sanctions at issue to be heard at SOA. Now, as a result of that response that I received from them, I said, okay, well, if there's no statute mandating it, let's make one. So today, when I hear Mr. Stick say that you can have a request or an option, it's foreign to me because I'm the guy in the pit. I'm the guy receiving the benefits. I'm the guy receiving the motions. So I've come up with a solution. If there's no mandate, let's make a mandate. Let's create 1536. 1536 is a very clear statute. It just basically says that if there happen to be an overpayment hearing, then you should take that overpayment hearing to SOA. Now, so all I'm doing right now is codifying due process. Now, what is a due process we're talking about? Due process can be very, very vague, but due process. The due process that I'm referring to is the due process that we need to have a fair and impartial, neutral magistrate. They tell me, you've got one, Canales. HSC are honorable people. They'll give you a fair shot. So wait a minute. If the HSC agency is the agency that conducts the audit, conducts the investigation, conducts the prosecution, now they've got their own judge, but they're honorable people. There's something wrong with the due process. And here's the bottom line. When they issue the damages by this judge, HSC, where does the money go to? It doesn't go to the general fund. It goes to HSC. So now I have a judge, HSC, who is making these decisions, who is be collecting a fine or monies or recoupment for his own agency. I mean, to me, it's abhorrent. There is not a single administrative agency, by the way, in the state of Texas that has this power. None of them. What power am I talking about? Look, if you happen to have a dentist, a Medicaid provider, who is billing for services that he did not render, you know what? Send him to the Attorney General's office. Get him indicted. Get him prosecuted. Because he's cheating. He's cheating. OIG doesn't do that. OIG, all they can do is refer this case over to Mafuco or the Attorney General's office. But in this case, what they're doing is they want to file civil litigation. All of a sudden, they'll say, you know what, I'm going to come audit you. I'll show up at your office, let me have 200 files. Pick up 200 files. Out of those 200 files, I'll have the first 63 that they say was randomly selected. I already took the deposition of their expert, so-called expert. They dismissed my case, one of my cases, by the way, because they couldn't hold up to it. Had a wrong methodology of doing it. But nevertheless, they pick up 63 files. Of those 63 files they look at, they'll say, something's wrong here. The treatment date's wrong. We disagree on the HLD score. We believe this is unnecessary service. Get those 63 files. I said, okay. Well, how much do I owe you? You come back and say, for 63 files. Let's add it up. Let's say it comes up to $50,000. Well, let's go ahead and pay the $50,000. It's cheaper than paying Canales. Let's work it out. So they go ahead and say, Mr. Stick, you've got 63 files that you want to look at. You know what? We're throwing the towel. In the interest of a good financial decision, business decision, we're going to pay you the $50,000. He says, no, I'll take the $50,000, but we're not through yet because you owe me more money. Well, how much more money do I owe you? Well, we've taken a sample of 63 cases. We created something called a payment error. We now look at the universe of cases for the last 7-8 years. There's 5,000 patients, and we'll apply this payment error to all these 5,000 patients. So now you owe me $1 million. For what? For these unknown cases that nobody has seen. Nobody's passed on it. Okay, well, I'll owe you that, huh? Oh, yeah, we're not through with it yet, boy. One more time. I've got the $1 million in my back pocket. Now we're going to sue you. We're going to add to it. Double it. Now you owe me $3 million. Wait a minute. This is a $50,000 claim. Now you owe me $3 million. And on top of that, we're not through with it yet. Now you're going to owe me, by the way, for lawyers' fees, expert fees, court costs, a little bit more there, here, and there. So we're talking about maybe $4 million. Well, but who decides this? Our judge does. What judge? The HST judge. The guy that works for you? Yes, that particular judge. What happened in my jury trial? When do I get a jury trial? When do I go to the courthouse? What happens to the preponderance of the evidence? When, by the way, has the Supreme Court of Texas decided, give me some facts here I didn't know about, when has the Supreme Court of Texas decided or approved as a measure of damages this extrapolation theory? They have not. They have not. So where do I go? Where does a citizen go to get the remedy? You go to the courthouse. Can I go to the courthouse right now? No, I can't. Because by the time I get to the courthouse, they already say I owe them the money. I owe them $3 or $4 million. It's a judgment, sir. It's a judgment. They can go up and collect from. The only thing you'll be safe from will be your homestead. Nothing else will be safe. They'll go get your savings account. They'll go get your boat, your cars, whatever's not exempt. And you never got to the jury. Well, am I not entitled to a jury trial? Now, if they want to be able to take away my license as the Medicaid provider, let's go to HSC. Not a problem. If they want to be able to say, I'm going to suspend your particular type of treatment, that's fine. But where did they get the power, sir, to be able to exercise this damages against you? The 63 files, for example, they look at. Try and get a copy of those 63 patient files. It is nearly impossible. How do I know that? I'm in the pit. I'm there with them every day. I've got cases against them. It's very, very hard to get this. Now, the point I'm trying to make of all this is that all I'm trying to do here in this bill is to codify the due process. Nothing else. Codify it. How do we codify it? Because, and I'll be more glad to submit their official responses, where they say, I'm reading it right now from one of those, where they say is, no agency statute mandates or permits appeals of the sanctions at issue to be heard at SOA. So when Mr. Stick comes up here and says, all you got to do is ask for it, I've asked for it, and this is the response they get. So I submit to you, we're not trying to get anything that's not fair for us. We're not trying to protect a Medicaid provider who's a crook. We're not trying to conceal or make it harder for anybody. All what we're saying is, if you're going to be going after us, it ought to be done with a series of fairness. How in the world can it be fair? How can it be fair if this so-called magistrate judge, the HSC judge, works for the agency that's going to be finding us, and the agency's going to keep the money? Does that not create an inherent conflict of interest? To me, it does. I have looked far and wide in all the Texas statutes. I'm looking for an agency, by the way, that has the power to be able to take away your money. Okay, let's go through some of them. Can agencies fine you? Sure, they can. Can they fine you? Can an agency fine you $100,000? No, they can't. Case law kind of brings out about $5,000 a shot. Can an agency without a jury trial take away some of your constitutional rights? The answer is no. We sign a contract. So we, the Medicaid doctor, the provider, signs a contract, not with OIG. We sign a contract with an agency called TMHP. And TMHP is the contractor, the vendor for them. But nowhere in TMHP is there a provision for arbitration, mediation, or waiver. Nothing. It does say you have the right, by the way, to be told that you will be subjected to all the Medicaid rules. Fine, we'll do that. But just because they pass, Mr. Chairman, just because they pass a rule that says I'm going to be able to charge you for damages doesn't give them the right, by the way, without any type of statutory authority, doesn't give them the right to impose those rights contrary to the Texas Supreme Court. None of these cases have been litigated. None of them. When this whole story started a year and a half ago with the WFAA stations, the whole story began with the payment holds. After the payment holds, we're slowly now moving over to the overpayment hearings. We're just beginning to get the overpayment hearings. So the money they have collected from overpayment, they haven't collected a penny yet on overpayment hearings. They haven't made any hearings. Not HSC. There has not been a single decision. Only one payment hold. I'm not talking about the payment hold. I'm talking about the overpayment hearings. So, how does your constituent from Laredo comes up to you and says, oh, by the way, Mr. Raymond, I happen to be a Medicaid provider. I happen to be received an audit. And now I've gotten this letter that says I owe them now the normal about $7-8 million. And I owe them the $7-8 million because they've come up with this extrapolation model. Which again, this extrapolation model is based, as you said so, on this particular statistical study. The only case law that's available right now is a Court of Appeals decision from Washington, D.C. on the Medicare system. But the Medicare has their own separate rules. And the Medicare has their own particular statutory guidelines and so forth as to how they're going to do it. We don't have it here. This, right now, we are on untested waters. And the question is going to be is whether or not you're going to allow Mr. Jack Stick and company to be able to hold judgments against doctors, Medicaid providers, without the benefit of a trial. To me, it's abhorrent. To me, the only way to cure this is to be able to look at this particular statute that creates or codifies due process.
One second. Chairman Zerwan.
Yes.
Thank you, Mr. Canales, and thank you for sharing your perspective on this. Let me just be sure I've got it straight, and I wanted Mr. Stick to kind of walk through this, and that although it would seem to be the practice of OIG or HHSC to allow for a SOA if we're asked and if granted, it sounds like what this bill seems to do is to codify the option for an appeals to SOA.
Yes, because it doesn't exist right now, sir. It doesn't exist. In spite of what he said, it doesn't exist.
Okay, so it's the practice isn't codified, and
that's right.
And so you're looking to want to make that practice a statute, and then Also in this law, it would appear that Mr. Guerra is saying that there should be the opportunity for a trial de novo in the Travis County Courthouse.
Because of the large sums of money involved.
Okay.
You know, Doctor, if we were talking only about your license, it should stay there because having the license, it's not a right, it's a privilege. Now, but when you start talking about people's property, you want to take away somebody's property, money, sums. Another set of rules comes in. And the other set of rules that comes in is the Texas Constitution. I have a right. If you can sue me, absent an arbitration agreement somewhere which has been upheld, absent that, I have a right, if you're going to come after me, to defend myself at the courthouse. The venue, by the way, in all these cases is Travis County, which is, I'm not arguing about that. But I have the right to be defending myself in Travis County. And I have the right, by the way, to challenge these experts. But I can't challenge them. Where do I challenge the expert on extrapolation? There is no venue right now to challenge them because I'm going before their own employee. Take me to a district court where something is called, we call the Dahlberg challenges, where I can be able to challenge the expert and see whether or not they're experts in that field. And is that expertise or the statistical model is an acceptable measure of damages? If I have a car wreck with you, we know what my damages can really be. My property damage, my car. If you injure me, I'll know what my property damages are. I can either suffer my broken arm, sore back, or pain and suffering. The jury will be able to decide that. But can I have as a measure of damages to the jury, if you had not busted me in this accident, I would have driven 10 more years, 25 more years, and had 24 other cars. And I want you to pay me for that. The answer, the Supreme Court of Texas will say no. The Supreme Court of Texas is jealous of the jurisdiction regarding the measure of damages of somebody. Question is this measure of damages going to be done by this unnamed extrapolation person, or are we going to be actually looking at the case? Now, the 63 files that they're talking about to have, we've got them there. We've got the doctor. We've got the patient files. But this 5,000 universe, where do they come from? So all of a sudden, you as the Medicaid provider, who said, you know, I wasn't even in the office 4 years ago or 3 years ago, you're stuck with it. You are now liable for this. And I submit to you, the only way to cure this is to be able to give me a trial de novo. I do not know, and I challenge them to tell me. Give me an agency in the state of Texas that has the power to sue you administratively and collect millions of dollars from you within their own agency. None. Zero. It doesn't exist. Why does OIG all of a sudden the last 2 or 3 years have gotten all this aggressiveness and say, you doctor, I think you lied and you cheated. And I'm going to apply this 63 files to every file you ever had. And now you owe me this money. Oh, by the way, you don't have a right to appeal. You don't have the right to. And these are my experts. And that's it. You give a judgment. It's not for funsies, for heaven's sakes. It's real money. The treble damages. It is. Representative, I am shocked. Listen, I'm a former federal prosecutor. Been around also. I've been at it. I've been practicing. I'm board certified. I've been at it for lots and lots of years. I have never, ever, even when I worked for the feds, I have never, ever seen an agency, I hate to say, run amok. This agency right now on this OIG business of collecting money, they're running amok. They are going around asking for all these doctors for millions and millions of dollars. And I'm at a loss, sir. I'm really at a loss. I came up with this idea. Representative Guerra and I'll go back many years. We talked about it. I'm at a loss. I am in a state of shock. How can we as citizens allow an agency in the name of ferreting out fraud be able to get this sums of money against our doctors, our citizens? Again, if they've done wrong, let me tell you one thing. I've got federal prosecutors chasing these doctors. I got strike forces. I got the attorney generals from the Fuku people. I got everybody. Nobody's bashful, by the way, about filing criminal cases against doctors. In the dental world, this is my world. There's been 2 doctors being convicted, 2 dentists being convicted up on the billing. And they all got caught doing one thing. Their billing for services didn't render. That's wrong. Cheating. Anytime they get into a situation about I'm indicting a doctor for coding, whatever, had Dr. Schwartz, my client, I defended Dr. Schwartz in the Valley, 20-count indictment in federal court. We won. Why? Because they're trying to get these vague notions to be able to make examples of people. Here, I challenge them, by the way, to tell me how many overpayment hearings they've had. He didn't answer your question how much they've collected. Oh, we've got on the books so much money. I've got 10 clients right now. And each of my 10 clients has about $7 to $10 million claim against them. But they haven't collected a penny. Why? Because we're challenging them in every step of the way. Why? Because it's our constitutional right to be able to do that, sir. So forgive me if I get a little bit excited about it, but I cannot imagine the system going on right now and the harm that they're doing to some of these Medicaid providers. They want to go after those 63 patient files. Fine. Let's do it. But this extrapolation of damages that goes all the way to, they call it what, the universe? Well, this universe comes out about $7 to $8 million. It's just awful. I'll be more than glad to answer any questions. I know you have a lot of more people, and so far I really appreciate your giving us the opportunity. But it's a very simple statute, but it needs to be correct. It's a due process argument. That's all it is. We're codifying the due process because they keep telling me in all their motions they filed, no agency, statute mandates or permits appeals of the sanctions at issue to be heard at SOA. I want to correct that. Let's have a statute that mandates it. How hard can that be? Now, they have a fiscal note. One more thing, I forgot about the fiscal note. They've now come up with this fiscal note that's going to cost them $1.7 million. I am shocked. They're going to have to add 23 parcels to this case? Where do they get that from? The same lawyers, by the way, who are handling the SOA case, the appeals courts will be handling the SOA case. Same people. They got the same experts. There's no additional expense. If it goes to the district court level, they don't follow the case. They don't follow the case. The case is then handled by the Attorney General's office. So I submit to you that the fiscal note they have is totally inflated, subject to a lot of questions on it. Thank you so much, Mr. Chairman. I know you've got a lot of people here. Helping me will be Oscar Garcia. Is he back? Oscar had to go see an appointment. He might come back. Any other questions, sir?
Members, any questions for Mr. Canales? If not, you might want to hang around too.
Oh, I'm starting to fight. I'm not leaving.
Okay.